足夠嘅法定。
Members, we now have a quorum. Let's invite the administration in.
我係去到嗰個咩仔嗰度。上次傾咗有一條係我停咗嘅，係去到 Magistrate 19啊。
我哋去到19，上次今次由20版開始
唔係，我上次停咗嘅，我話要問佢嘅係邊一條啊？佢話因為經濟係啊呢條嚇第7條0019。邊位係退休啊？今日但係佢哋都喺度啊嘛，你咪一個嘅。好，歡迎官員嘅代表出席今日嘅會議。
I'd like to welcome the administration in. We are now on to page 19 of the marked up copy of the bill. Today we are deliberating on the Judicial Officers Extension of Retirement Age Amendment Bill 2019. Last time we stopped at page 0019 and I will continue with my question. So for officers who are not district judges, and we are talking about Part G, and upon completion of qualifying service of not less than 2 years, there might be compulsory retirement for the purpose of facilitating improvement in the organization of the judiciary, by which greater efficiency or economy may be effected. Last time we were referring to judicial officers who are lower than the level of magistrates. Due to facilitation of improvement in the organization, by which greater efficiency or economy may be affected, well, we shall allocate 5 minutes for one question. I think economy is not a matter in question. LegCo is always fully supportive when it comes to manpower funding, and we are not just talking about judges. We always feel that the judiciary should recruit more judicial officers, so the problem of economy should not be a question. For certain levels of judicial officers and judges, the threshold is high, and as such, some people are reluctant to join because the career ladder is steep. But the officers at the lowest level do not enjoy protection, and this is in contrast to a tenure arrangement. Judges will have their retirement ages pushed back by 5 years. For the younger officers, say those with 5 to 10 years of experience, however, they do not enjoy employment protection. So can they return to the private practice anytime. That's my question.
嘅畢業生，我都好希望問清楚呢個問題。
This is a question I would like to ask. Patricia? There is a historical context to this provision. The judiciary enjoys certain powers of employment. Certain powers under the civil service regulations are vested upon the employer, and the employer might invoke certain such provisions to achieve greater efficiency or economy. These provisions are in place and they are irrelevant to the current amendments to the retirement age. Later, we can review such provisions to see whether they are up to date, but they are irrelevant to this amendment exercise. You didn't answer my question. So for judges at lower levels, so after they are forced to retire, can they return to the private practice? They could be forced to retire or face compulsory retirement for the purpose of achieving greater efficiency or economy. So can these officers return to the private practice? For judicial officers, including magistrates, there is no provision saying that they cannot return to the private practice. In other words, they are free to do so, yes. So for judicial officers at lower levels or magistrates, they are an important part of the judiciary. Why are they being ignored? My point is, you have not considered judicial officers at lower levels quite enough. So I hope you can appeal to younger talents, and currently this is a challenge for you. You should visit law schools and talk to their graduates. You should talk to young practicing lawyers. Why didn't the judiciary appeal to them? This is something you must address going forward. And the members present today are from the legal profession. Of course, we would support the retention of talent, but attracting new blood is even more important. What will happen 5 years down the road? You are going to face a brain drain, and yet you fail to attract new talent. I think the terms being offered are even worse than university instructors. You are now dismissing officers on the ground of efficiency or economy. I hope you understand the message. Thank you, Chairman. For officers on or above the level of district judge, there is a protection to their tenure. The tenure is guaranteed till retirement, and after they retire, they cannot return to the private practice. I think this arrangement is clear for everyone. For officers below the district judge level, including magistrates, there is no guarantee of tenure under the basic law, and they are allowed to return to private practice later. There are different subclauses in the bill for item G. When we set up the judicial officers pension, we refer to relevant provisions of the civil service regulations, including retirement age. We copied the provision at that time. However, this was never invoked. We can see whether this can apply to judicial officers, but the focus of this amendment bill is not to review or amend the entire ordinance on a wholesale basis. So this is not the focus of our exercise. So in the future, we can see whether any provisions warrant amendments. So for judicial officers below the level of district judge, after they leave the judiciary, they can return to the private practice. The reason is that there is no guarantee of tenure under the basic law for these officers. Thank you. We understand the situation, but I think some officers are being neglected. I am very concerned about young law graduates. We have more than 1,500 practicing lawyers. I believe many of them are interested in joining the judiciary. I hope you can discuss this issue with young law graduates. You must let them know that they are free to return to the private practice. In a lot of commercial contracts or civil service contracts, such provisions are in place. But now you are really neglecting young judicial officers on the ground of efficiency or economy. I think economy should not be in question. The provision is outdated. The safeguards enjoyed by civil servants and judicial officers are very different. I think this provision should not apply to the judiciary.
I hope that you can bring this message back and even talk to the judiciary about this, because I don't think that this provision should be included. Okay, Mr. Cheung Kok Kan, 5 minutes, please. Well, I don't think I need so long. I didn't come to the last meeting. The district court level judge should include judges at the lands tribunal. Am I correct? Because my understanding is that they should actually have equal standing. But in the ordinance, I do not see where the lands tribunal judicial officers are included. Mrs. Ann, please. Thank you for your question. There are judges at lands tribunal, and they are actually the district court level judges. There are also members. These members are professionals such as surveyors, and they are not judges. They are actually professionals. Well, just now you talked about officers at the Court of Final Appeal would not be affected. So does this guarantee and protect judges from the lands tribunal? But would you say that there would be different treatment when they're acting as judges in different areas? Lands tribunal judges are actually seconded by district court level judges, so so it's just like a posting that would not affect their tenure. Well, so their tenure, it's just that they have been posted to lands tribunal as a judge. Oh, well, we are all from the legal sector. I really hope that you can make it clear so that young practitioners who join the field could become magistrates after 5 years of practice. Last time, Mr. Junius Ho asked about lifelong tenure. I think that you should let the young practitioners understand what they can look forward to in their career. Any other questions? If not, let us move on to 0020. Ms. Chang. Thank you. So here is a qualifying service. Qualifying service of not less than the relevant period specified in paragraph A has been amended to specified period of qualifying service. And here in this section, specified period means means the starting date of receiving pension. The second change is to change the term shall to is to. We have already explained it. This is only a drafting amendment. And moving on, the triangle, which is bracket 4, we have specified what it means by specified age. We used this earlier. We would take into consideration when the age of retirement would be, as it would sometimes be 60 and sometimes be 65. It depends on whether they are current judges, whether they have chosen the new system. And the specified period I've already explained earlier. If there are no questions, we move on to 0021. Thank you, Madam Chair. This is actually amendment in clause 8, specified age, and the definitions are listed out below on whether which retirement age they are subject to. And some may get an extension in retirement age. So this is referred to as 7, 1D, A, D, E, D, F, and DJ. So the specified age, this term has been changed to specified age because of the changes in the age in the amendment. Well, so that depends on which position that person is. And that person can choose which retirement age arrangement he or she would like. Yes, so they can change, and at the same page there's a drafting change from shall change to is to. I would like to invite members to also look into the English we're also looking at the English version right now, so we can read both the Chinese and English version together. Moving on to 0022. Thank you, Madam Chair. We are just making changes to the title because we amended this 30 years ago, and this is the same with civil servants because at that time civil servants could also change which pension they would arrangement they would like. And some family members may still be receiving pension, and we want to also to have the same legal basis, and therefore we did not take out that term. But now with amendment, we have made this clear that we want to make sure that we make clear the difference between the previous and the old and the new one. So we are now changing it to service attracting pension under pensions ordinance. So this is actually from the 80s when the pension was moved over to cap 401 under the pensions ordinance, and this change can help better understand that this is already in the past. No questions? Well, we move on to 0023. Thank you, Madam Chair. As I've said, 10 and 11 are both similar amendments to make clear that this is actually in relation to the old pensions ordinance. If members do not have questions, then may I refer members to clause 11. 11A is new to make it clear which specified officers can opt for retirement age arrangement under caps 401. Well, as it is a bit complicated, let me read it out to you. Subsection 1, a specified officer is listed here. And there is a definition under subsection 2 stating that it refers to Chief Justice or a permanent judge, a High Court judge, a district judge, or D, an officer other than the Chief Justice, a permanent judge, a High Court judge, a district judge, or a special magistrate. So we have explained why we do not include special magistrate in the opting arrangement. It is because these special magistrates would gradually phase out, and we are not going to recruit this position. Therefore, there would be no changes made to the retirement arrangement. There are also other requirements, and back to subsection 1, there is both A and B. A points out that the officer was appointed on pensionable terms before the commencement date of the 2019 ordinance, and B, on the commencement date, the officer has not yet attained the normal retirement age, or the officer's existing term of office has not yet expired. So that was a current judge or judicial officer at the commencement date. So we will invite them to opt for either the old or the new arrangement. Well, you're not going to recruit any new special magistrates. So do you still have this position now? Mrs. An, please. Yes, there are still six special magistrates. Well, do any of them need to extend their retirement? Well, this position is gradually phasing out. Well, for those who are about to retire, of course they will retire. For the younger ones, we encourage them to sit the magistrate exam. We hope that if they pass the exam, then they would move to become magistrates. So you are saying that special magistrates would not benefit from this amendment. We have not included them this time. Mr. Holden Chow, Madam Chair, well, maybe I am way ahead, but I would like to ask about 11B. It talks about the notice for opting for retirement age arrangement. Well, I just want to ask a question because I'm afraid I may forget. I see in 11B bracket 3 it said once delivered, the notice is irrevocable. I'm not sure whether my understanding is correct. Is it true that once they have opted for retirement age arrangement, regardless of any special circumstances, it will still be irrevocable? Am I correct in my understanding? Ms. Chang. Thank you for your question. Oh, you are correct. We are going to issue a notice, and no changes could be made afterwards. But as we have said earlier, if a judge has chosen the new arrangement, it is flexible. You can choose an early retirement arrangement. Let me use a high court judge as an example. So the retirement age can be extended from 65 to 70. But starting from the age of 65, if there are any reasons that he wants to retire, he can apply for early retirement. And for these higher level judges, we have also included a discretionary retirement arrangement. So from the age within those 5 years, that because of health or family reasons he would like to retire a bit earlier, with the approval of the chief judge, and he could choose to make early retirement. So there's still a flexibility over there. All right, I understand. I just want to ensure that there would be such a protection, because it says that the notice is irrevocable. But since there is a flexibility, then it will be better, because sometimes you don't know, there might be sudden health reasons. Well, my understanding is that so maybe there is a scale that once you have delivered the offer, maybe you cannot revoke the offer from the side of the judiciary. But now with Ms. Chang's explanation, since the officer can still choose early retirement even with the new arrangement, that is a very good flexibility. All right, let us move back to the special magistrate. I have a comment on that. I hope when we are making amendments, we put more consideration on junior officers. Do they not fulfill the criteria, or I mean, this is a question I want to try to understand, because we already is it because we have enough magistrates? It's not like in the high level when you already have enough magistrates, so there wouldn't be an issue of extending their retirement age. Well, this is actually an overall arrangement. We have also extended retirement age for magistrates. Right now, the retirement age is 65. So this time, we have also extended from 60 to 65. So you can see that there is also an extension arrangement.
This only applied to special magistrates, right? In a recent review, we decided that we would phase out this post. Are you referring to people without a degree in law? I think the credentials or qualifications are identical. Can you explain this? With the exception of a grandfathering arrangement for a small number of special magistrates, the rest all have a law degree. In the early years, no law degree was needed for special magistrates, since the cases were more straightforward at that time, and the manpower situation was tight. And as we saw more graduates with a law degree, the entry and experience requirements of magistrates and special magistrates are the same. So we encourage law graduates with the experience to apply for the post of magistrates. The complexity of cases nowadays is very different from a long time ago. And many law graduates can actually apply for the post of magistrates. So for the current special magistrates, we would encourage them to apply for the post of magistrates. That way we would slowly phase out the prevailing special magistrates. When we discussed the elimination of special magistrates, many of them did not hold a law degree when they joined the judiciary. But now you are telling us that the entry requirements of magistrates and special magistrates would be the same. Why are you exempting these officers from the ordinance? If the entry requirements are the same, why would they have to apply again? We have a small number of officers who receive a different kind of law training, but just now your explanation seemed to be different. Why are you excluding these 6 officers? We want to gradually phase out the special magistrates. So what is the difference? If their credentials are same, so special magistrates treated differently. The grade of special magistrates was created a long time ago, and the entry salary would be lower, and the judicial power is lesser than that of a magistrate. And through the public examination, we hope that they can become magistrates. So the main reason is that you do not want to retain this grade, yes. Let's move on to page 0024. Ms. Odenchow asked about section 11b brackets 3. This is an arrangement on the choice, and according to subsection 1, an officer must deliver a written notice in a specified form to the judiciary administrator. In subsection 2, the timeline for delivery of the notice is mentioned under brackets A. Normally, the choice must be made before the expiry of 2 years from the commencement date of the ordinance. And paragraph B specifies that for an officer attaining the normal retirement age before the commencement date, for instance, if an officer will reach 65 years within 2 years, let's say if the officer would reach 65 years of age 1 year after the commencement, then they have to make a choice after 1 year. Under paragraph C, if it applies to cases if the officer's term of office is extended. Paragraph D is about continuation of service, and the officers concerned must serve a notice beforehand. And paragraph E, if a notice is submitted for resignation or retirement, then the notice must be served by the effective date of resignation of or retirement. So these lay out the arrangements for different scenarios. And according to subsection 3, once this notice is delivered, the notice is irrevocable. Any comments from members? If not, we move on to section 11C. The transition to a new arrangement is administrative in nature, and a lot of details are involved. We would allow the Chief Justice to issue a circular providing details of the relevant arrangement to JJOs. Any questions? If not, we will move on to page 0025. We will insert a new section 12A, discretionary early retirement. First of all, under subsection 1, for the more senior judges or judges above the level of the High Court, there could be discretionary early retirement provisions. They can, the judges can stay until the age of 60, and between the age of 60 and 65, early retirement is allowed, so long as notice is served 1 year before. So within the 60 to 65 age bracket, judges can apply for discretionary early retirement. Subsection 2 is about the parties that would approve the applications, either by the Chief Executive or the Chief Justice. And subsection 3 specifies that the Chief Executive or Chief Justice may approve an application only under exceptional circumstances. And they would have to look at the need for senior judges at that time. For section 12A brackets 3, would exceptional circumstances include non-health related factors? Health could be one reason. Family reasons are also included. So we would allow flexibility for the Chief Executive or Chief Justice, because there could be many different circumstances. Any questions? If not, we move on to section 12B. If the Chief Justice is to consider discretionary early retirement, there could be conflicts of interest, and to avoid that, we are assigning an arrangement. For instance, if the Chief Justice receives an application that involves conflicts of interest, other judges would be appointed to deal with the relevant applications. And under subsection 1A, and within the CFA, there are permanent judges. We would identify eligible permanent judges who can act as the Chief Justice. We would first identify the most senior judge who has no conflict of interest, and these permanent judges would be highest on the list. And in paragraph B, secondly, among the permanent judges who are not eligible to be appointed as the Chief Justice and not subject to any conflict of interest, they can also deal with these applications. And failing all that, we will move on to criterion C. And that is any other officer considered suitable and not subject to any conflicts of interest. Subsection 2 explains the seniority of a permanent judge, and the seniority is to be determined in accordance with the order of precedence prescribed in Cap 484. Subsection 3 defines conflict of interest. It means an actual or apparent conflict of interest. Mr. Horace Chang. So for permanent judges who are eligible or not eligible to be appointed, what are the differences? Thank you. Under the CFA ordinance, there are different requirements in place. So in practice, nationality is one of the considerations in deciding whether a permanent judge is eligible. Ms. Lam? Under Section 5 of the CFA Ordinance Cap 484, the criteria for acting Chief Justice is laid out, and the seniority is laid out in Section 11. It defines the order of appointment as Chief Justice. The types of district or permanent judges that can be appointed Chief Justice is laid out in Section 5. I mentioned the nationality requirement because in Section 6, capital A, it says the judge should be a permanent Chinese resident with no right of abode in any foreign country.
So this is one of the requirements, but of course there are other considerations. The Chief Justice has also has a Judicial Officers Commission. So that is actually some of the considerations. Well, the nationality criteria is under Basic Law, Article 90. So if there's actually a conflict of interest, the other person who is eligible will also need to fulfill the criteria. Well, yes, for the first batch, but as I've said, there are actually 3 groups who may be eligible. So we would first consider Group A to look for permanent judges who are eligible to be appointed as the Chief Justice. These judges can be acting Chief Justice, which means that when the Chief Justice, due to certain reasons may not be able to act as Chief Justice, then we would look for permanent judges who could act as a Chief Justice. And these eligible judges would be appointed as the Chief Justice. These judges should be quite familiar with the administrative procedures, so we believe that they should be the priority group to be appointed as Chief Justice. Mr. Junius Ho. Madam Chair, I'm curious. I just want to ask about 11B. I'm talking about CAP 484 on the seniority. So you look at the date of commencement of the tenure. So let's say a former NPJ, a former PJ who is now a non-permanent judge, and he's at the age around 68 and 69, or let's say he wants to re-enter the service, and then he is accepted. So how would you look at the seniority? Would he actually be considered on when before he retired, or how would you place his seniority? Or let's say he was already a PJ in 2004 at CFA. Now after retirement, he's a NPJ and he's still not at retirement age. So he applies and then he goes in for a PJ. So would you consider his seniority from 2004, or would you look at his seniority as a new entry in 2019? Well, it's not very clear here. Here, they said that should rank and priority in respective of their appointment. Well, it's not very clear here. Well, it's not urgent. Perhaps you could give me an answer afterwards, unless Mrs. An can answer the question. It would be best if you could answer the question. If not, please reply in writing. Well, we don't see these cases. Well, it's unprecedented. But you know, with this new amendment, can you rule out NPJs applying again because their age is fulfills the criteria? But I'm not sure whether when you consider a PJ application, I don't know how you consider these positions. We already have retired PJs who come back as NPJs. Well, how about if they want to apply to become PJs from NPJs? So that means that person has already passed retirement age. Well, let's say he's age 68. Well, let's say he has not yet passed the extended retirement age. What would the situation be? Oh yes, so that's why I'm asking you how you would count the seniority. Patricia, do you have any add-ons? Well, I believe this is quite important because with this amendment, you want to attract more experienced judiciary talents. Now, these PJs have already worked in the CFA. If they're still healthy, you might want to attract these talents back into service. So how do you count their seniority? Madam Chair. Well, this is a hypothetical question. I'm sure GLRC will consider all these aspects. This is unprecedented. Well, I don't think this is an extreme situation. It might happen. Well, so it might happen that if you reappoint a NPJ to become a PJ, would you still rank his seniority as before? Have you considered this problem at all? Well, there are two questions here. First of all, a retired PJ becoming a NPJ, let's say he's still young, he might want to come back as a PJ, and is his seniority counted as the second term of office or the first term of office? Well, it's not very clear under the law right now. Maybe this is something we'll need to look into. A legal advisor. Well, I don't think it should be confusing because B points out that it must be a permanent judge. Well, if they become an NPJ, then you wouldn't consider that. And for C, if under C, the authority lies in the CJ, so the Chief Justice will be considering the seniority. So I don't think there would be a confusion in operation. Well, since a member has raised this question, well, I think we should also look into it because this is a member's view. I personally think that you could just count the years of service altogether. I don't think the seniority should become the lowest because this is already a very experienced and respected judge. So when we pass this legislation, this is just a view we would like to raise. Of course, you could throw the ball back into the court of the JORC. However, legislation should be clear so as not to be vague. Let's say this PJ has already worked in CFA for many years, and even if there has been a temporary stop in between, I think we should consider all the years of service. So this is just a comment and view we have for you. This is our responsibility. I don't think it is all right just to defer this back to the JORC. I think you should also put this into consideration. I have a question on the definition of conflict of interest. Here you put down apparent conflict of interest. There are many definitions under the common law. I myself teach administrative law as well. This is under common law that there is apparent law of bias. You need to find proof for that. Let's say there were sort of previous conflicts. We might want to be safe and declare interest. For example, we might have some different views on environmental issues. strictly speaking, that shouldn't be considered as an apparent conflict of interest. Well, it might actually be a conflict with a personnel, but there might not be a pecuniary interest. And let's say everyone knows that they have disagreements. Well, so there should be a way in which they could declare interest and continue to sit in. Or have you considered all these other circumstances? Well, judges know how to handle actual or apparent conflict of interest. Therefore, when we considered this, this is not actually a case. This is only an application. There are so many permanent judges. If none is suitable, then the Chief Justice can appoint someone else. There are many choices. Therefore, we want to play it safe, to try to make the definition broader so that people would not feel that there is a bias in appointment. All right, so this is actually a safety measure. Yes, the clearer the better. Well, so this is good because no one will fall into the trap of conflict of interest. Well, there are some applicants who might put in objection all the time saying that, oh, I have conflict with this person, I have a conflict of interest with the other person. Well, this is the reason why I have raised this question, because I see that sometimes even with a low gravity of conflict, they still say that it's a conflict of interest. Well, I accept that you are using this as a safety measure to prevent confusion. Let us move on to 0027. Oh, this is only a minor change. Here you see section 7, 1A, B, K, J. We are just now extending it because there is a discretionary retirement arrangement. Therefore, we just want to make it clear that if their officer if there are any disciplinary proceedings brought against him, then there might be a change to the pension arrangement. So we want to make this consistent, and therefore a minor change has been made. So, oh, this is only disciplinary proceedings, or are you going to remove him from position?
Under section 29, subsection 1, if pension would not be granted to an officer due to certain acts conducted by that officer, and scenario B is that the pension is cancelled or reduced, so other laws would deal with the disciplinary action. Under subsection 2, having considered the advice of JOG, if there's a decision to refuse to grant a pension or cancel or reduce a pension, and the disciplinary actions are laid out under brackets 1, or that is the officer retired, has any disciplinary proceedings brought against him. Mrs. Ngan, under subsection 2 of section 29. upon retirement of a judge or judicial officer, if the retirement is to dodge certain disciplinary actions, so if that is the scenario, JOC might decide that the pensions might be reduced. So this is a safety net arrangement. Is this in line with Article 89 of the Basic Law? Article 89 applies to such scenarios. I think these align, right? Article 89 of the Basic Law lays out the dismissal arrangement and that a panel would be formed by the CFA. This is a good arrangement. Any other comments? If not, we move on to page 0028. Thank you. There is no amendment here, so perhaps we will move on to 0029. Amendments to the Hong Kong Court of Final Appeal Ordinance Cap 484. This is page 29. A new section 13 capital A is added on meaning of retirement age. So there are two scenarios to the permanent judges. Most would retire at 70 in the future, and B, it refers to judges who do not opt for the new system and they will still retire at age 65. And at earlier meetings, we talked about the High Court Ordinance or District Court Ordinance, and there are relevant extension arrangements. The circular meaning refers to non-pensionable judges. They can also opt for an arrangement. Retirement age extension arrangement refers to the arrangements provided by this amendment bill. I'd like to take a look at the original section 13.
呢度呢就英文就係 a person who has been appointed as a CJ, a PJ or NPJ shall not be entitled to practice as a barrister and solicitor in Hong Kong either while he holds office as such a time as a judge and at any time after he ceases. 呢度呢就係嗰度啦，係嘛？就係完全。
So in other words, they cannot return to the private practice at all as a barrister or solicitor.
咁佢係咪？我想知道係咪絕對冇空間嘅？其實呢啲做過呢啲。
I'd like to know whether there is no room at all to return to private practice.
Ceases for any reason to hold office as such a judge and shall be deemed upon and by virtue of such appointment to be not qualified to practice as a barrister and or solicitor. 佢停咗做法官之後，佢都唔。
So after they no longer appointed a judge, they cannot return to the private practice. Is that correct? A person who retires or resigns, they cannot return to the private practice.
好，大家有冇意見？
Any comments? Dr. Junior So. before the clause-by-clause examination, I've said that the spirit of the amendment is to appeal to talents who want to become judges at the judiciary. And we always face a bottleneck. And we also discussed the issue of job. So we were concerned whether a revolving door arrangement is possible. And for the Chief Justice, permanent judges, and non-permanent judges, this is covered by the CFA ordinance. And at any given time, that person cannot return to practice as a barrister or solicitor. And there are similar arrangements at the Court of First Instance. Why are we barring judges from returning to the private practice? We must adopt new thinking.
Bono 咧，呢啲都係人才嚟噶嘛。
These are talents, and some judges might not want to return to private practice for the money. They might carry out pro bono work. So while he holds office as such a judge, or at any time after he ceases for any reason to hold office, I think I will delete these words. Amendments to Cap 484 is not enough. There are only about 15 NPJs at the CFA. Some of them are not practicing lawyers in Hong Kong. They only practice in the Commonwealth. But the biggest pool of talents comes from the High Court and District Court, and that is the Court of First Instance. I want to move a CSA to delete the phrase I mentioned, and at the High Court and District Court rules, I would make the same amendment. I might not be doing that today. We must remove barriers. We must do away with old thinking. We cannot bar judges from returning to the private practice afterwards. You can introduce a sanitization period of 3 to 4 years. If you deprive such persons of the right to practice, this is against our principle of attracting talent.
講過幾次嘅我或者我都利用你嘅時間，我跟進一下。
I would follow up on an issue. I think this is an issue of rights. I think it's right that we discuss the issue at LegCo. For retired judges, they might continue to contribute their expertise at commissions of inquiry, and the Electoral Affairs Commission might also appoint judges. So can they take up roles as legal advisors or consultants? Sometimes they might not have to be engaged as practicing solicitors. And as things stand, there are limited opportunities for them to exercise their talents. So if you adopt higher standards, you can avoid conflicts of interest. Even if an officer has presided over many cases, they should still be allowed to utilize their expertise, and this would only benefit our society. So I think we can start a discussion on this. We should not slam the doors shut. So it might be difficult for the judiciary to make such proposal themselves. I know some outstanding judges who became academics since they do not like the environment of the judiciary. So this is pretty much a pity. We are talking about young individuals who are just 40 or 50, so this is a cause for concern. I have seen cases like that. These are very outstanding judges, and they were still very young when they left the judiciary. So what would happen to them? Would there be special approval? So the bar of conflicts of interest is very high. So long as you can prevent conflicts of interest, can something be done? Dr. Junius Ho has offered the same suggestion a number of times. So this is something we want to add. Anything in response? We note the views of members. But this is a long-standing practice which can help maintain judicial independence and reassure the public. We do not feel that relaxing this requirement is appropriate. Of course, we must be prudent because this has to do with the tenure of the officers. Let's say, can I opt for a 5-year term at the as district court judge? So after 5 years, an officer might feel that he doesn't like the environment of the judiciary. So would an extra option be provided? I was merely offering a recommendation. So there are different practices in different jurisdictions, even within the common law jurisdictions. So a tenure system is certainly important because it gives them a sense of security and commitment.
proportional 嘅，你揀 tenure 可能你就冇得翻轉頭。
So if you choose tenure, then there may be no going back. Dr. Junius Ho. Thank you, Madam Chair. To convenient us in the future, perhaps Jennifer or the judicial administrator look into similar clauses for magistrates and for other judges, so we can be clearer on this clause. And you've said that this has always been a long-standing practice. However, there are many other ways, and I really cannot accept that you are just going to follow in your old ways. We must change with times. Now, retired judges can also work in arbitration, which is a kind of litigation. So, retired judges can act as arbitrators or advocate for arbitration. But they also adopt the rules of procedures of CFA. So you cannot say that arbitration is only between two parties and it must be kept in confidence. There's also conflict of interest that needs to be considered. And you must be neutral as an arbitrator. However, if you're only an advocate for arbitration, you don't need to consider this, as you only act in the interest of your party. I think we must think ahead. I'm not asking you to make a decision right now. If that is the case, I would have moved a CSA. We should not rule out the possibility that these could occur in the future. So we must first take this first step. Please look for relevant sections and provisions so that we can also use it as reference. All right, but I would like to clarify that there is no such a requirement in magistracy. All right, well, the magistrate issue has been discussed for a long time. If you want to widen it to the district court, we could perhaps consider an option for them at their commencement date. Dr. Junius Ho, on May 21st, please join our meeting with Chief Justice Ma. He's going to speak with LegCo members. I'm sure that we could start a sincere dialogue with him. And this is something we can discuss in the academic circles, and then to look into the pros and cons of this long-standing practice. All right, moving on to 0030. These are all technical amendments. For example, 10-year of office changing to term of office. Do you need the drafting council to supplement? Ms. Kwok. Thank you, Chair. Well, let me first explain why we changed from tenure of office to term of office. Because we see in Cap 4 that all for judges and for district court judges, they all use term of office. This is easier to understand. And it doesn't necessarily mean only security of tenure. So we want to make this legislation consistent. We don't want the tenure of office for a CFA to be different. And we change a retiring age to retirement age. We want to make it consistent because we see in other legislation that the term retirement age is used, and therefore we've decided to make it change. All right, so there have just been minor changes to the wordings. Any questions? If not, legal advisor. Thank you. This is not only retirement age. There's also an extension of the retirement age from 65 to 70. Yes, this is under 14B. Any other suggestions or questions? So I see improvements made. If there are no questions, let us go to page 0031. Thank you, Madam Chair. The amendments on the top are also minor changes to the wordings. The more important amending is in new section 14A, transitional provisions relating to retirement age arrangement. So this is for the arrangement similar to the Chief Justice and Permanent Judge arrangement. So first of all, we listed out specified judge, which means Chief Justice or a Permanent Judge. And there are small letters A and B. A, saying that term of office has been extended under Section 14(2)(a) before the commencement date of the judicial offices, and B, these include those who have opted for retirement age. Let's say they already passed the age of 68. We would first arrange for bridging extension to first extend the retirement age to 70. So this is the arrangement under subsection 2. Subsection 3 refers to a further extension. This is different from the extension of the High Court because the total term cannot extend 5 years. But for CFA, it's 2 times 3. So every time the period should be 3 years, and it should not be extended for more than 2 times. So under subsection A, it said that the judge's term of office is extended under subsection bracket 2 when the judge attains the age of 70 years. So that is the maximum limit. And B states that there is a possibility that the extension can be extended to 70. So two 3-year periods, and that would be extended to 70. So there can only be a 2-3-year term when the judge's extended term of office expires. The principle remains the same. So the longest period would be 76. No, it's 77, because if in the current terms, if you extend it to the maximum, then with 2-3-year terms, then that would be 77 years of age. But that would not happen frequently. So that has not yet been done, right? No, because right now the maximum age limit is 71. Well, but it's up to when the commencement date will be. How about overseas legal practitioners? Oh, they do not have any age limit. No, they are not actually limited by age. No. Any other questions on this? If not, I just have a question. I missed one point in 0023. Just now, Ms. Chung said that the ordinance is already outdated. Perhaps I could refer to Ms. An, because in 1988, our understanding is that civil servants and judges use the same pension ordinance. And there were changes made. And now we have a name, a new pension scheme, old pension scheme. we also took out judges and the judiciary from that at that time, and to take it out of the pensions ordinance, because at that time we saw that the judges' retirement arrangement differs from that of civil servants. Clause 9, 10, and 11, which is set out in pages 22, 23, all refer to options 30 years ago. That was applicable before that, but now we have new arrangements. So we can now repeal the old arrangements. But after seeking legal advice, we see that many judges made those options on that ordinance at that time. And we are afraid that if we suddenly just repeal all these ordinances, then there would not be an opting arrangement mentioned, and it may affect the legal interpretation. We just want to ensure that there is a safety measure to protect all those who may still be drawing pension from that arrangement. But we don't want to make it confusing to current officers that there is still another option. Therefore, we just want to make it clear that that is actually a pension from before. So we decided to change the title to make sure that everyone will understand that that was an option 30 years ago. Yes, we only changed the title. We just add in the sentence regarding service attracting pension under pensions ordinance. All right, I'm clear about that now. We have completed 0032, right? 0033. All right, to the last page. This is just another technical change from changing the word retiring to retirement. Members, well, you do not have any more questions, am I correct? I'd like to first thank the administration for scrutinizing the bill with us, and also like to thank the legal advisor for going through this paper with us. First, on procedural matters. We have already completed the clause-by-clause scrutiny of the bill. I would like to ask the administration when you would like to resume second reading of the bill. I think we need to go back and look at the timetable to see when it would be most suitable. All right, because once you have made a decision, we need to submit a report to the whole House committee. I hope that you've already marked down some of the questions we wish to see written replies. So many issues have been cleared up in the scrutiny of the bill, and we hope that we'll be able to attract more young talents. I hope you would consider all our views and try to come up with ways to attract more talents into the bench, especially young legal practitioners. This is the reason why we're looking into extension of retirement age to not only to retain our talents but also to attract new ones.
法律意見顧問有冇補充？
Legal advisor, members, would you like to add anything? If not, we shall wait for the government's indication on when the second reading debate would resume at LegCo. If we have no any other business, I announce the meeting adjourned. I hope the government and judiciary understand that it takes time to scrutinize a bill at LegCo, and I realize that members are fully supportive of the extension of retirement age for judicial officers. Thank you.